In this class, we'll discuss very briefly of the most important aspects, fundamental rights, the doctrine of eclipse. We all know that fundamental rights are very essential for well-being of the individual. So, in order to ensure these fundamental rights are safeguarded, there are some constitutional mechanisms that are provided in the fundamental rights, particularly in Article 13. Article 13 says about three aspects. So we'll discuss all those things which are related to safeguarding the fundamental rights, which is provided in Article 13. And there are other provisions to safeguard from executive action, that is through Article 32 and 226. But this Article 13 is majorly discusses about legislative safeguards, no safeguards of the fundamental rights from legislature, or the laws that were already existing before the commencement of the constitution, pre-constitutional laws and post-constitutional laws, and any law that will be brought by the parliament or state legislative assemblies. They are inconsistent with the fundamental rights. They will be null and void. So we'll discuss in this brief class whether what does it mean by doctrine of eclipse. Does it apply to all the pre-constitutional laws, or does it apply only to the few important laws of the pre-constitutional laws, or does it also apply to the post-constitutional laws? So we'll be discussing all the aspects related to the doctrine of eclipse, and we'll also discuss briefly what does it mean by Article 13 and various Supreme Court judgments which are associated with the doctrine of eclipse. As you could see on the screen, we'll be discussing now on doctrine of what? Eclipse. So doctrine of eclipse. And my name is M.K. Reddy, as you could see on the screen. So before we discuss doctrine of eclipse, it is very essential to understand what does Article 13 of the Indian Constitution says about. It says about the laws which are there before the commencement of the Constitution has to supplement the fundamental rights. If they are not, they will be declared null and void. And to ensure the fundamental rights supremacy over the laws, general laws, this is provided in the Article 13. So Article 13 clause 1 says that any pre-constitutional laws which are inconsistent with fundamental rights will be declared what? Null and void. And Article 13 clause 2 says post-constitutional laws which would be brought by the legislative assemblies at state level and parliament, that is Lok Sabha and Rajya Sabha at central level. So if these laws, if are inconsistent with one provision or more than one provision of the fundamental rights, they will be called what? Unconstitutional, null and void. And the third clause of the Article 13 says about definition of law. What does it mean by law? So we'll discuss in general, law as per Article 13 clause 3 is any ordinance, any acts, laws, or permanent laws made by the executive. All these are called as what? The law, the definition of law. So we will focus particularly on this pre-constitutional laws, which is Article 13 clause 1. There are various cases. In this case, Pikaji Narayan versus State of Madhya Pradesh 1955, Supreme Court said that any pre-constitutional laws, they are abridging fundamental rights. They are against fundamental rights. However, if they are important, maybe their applicability is possible in near future or in future, or those provisions are not offending the fundamental rights of all sections of the society, then these kind of laws will not be declared null and void. This will be brought under the shadow of fundamental rights with the help of a principle which is called doctrine of eclipse. So the doctrine of eclipse will be applied to the pre-constitutional laws which are inconsistent with the fundamental rights. And Supreme Court said beautifully that The moment when this inconsistency vanishes or removed by the legislature, so there is a chance of application. So there is a utility. So keeping this thing in mind, the Supreme Court said that in Bikaji Narayan case in 1955 that the pre-constitutional laws will be would continue to exist but would not be enforceable, and they will be in the shadow for fundamental rights. And this concept is brought in the 1955 by Supreme Court to safeguard, to ensure the deletion or complete removal of pre-constitutional laws. So pre-constitutional laws will survive despite being against the fundamental rights. However, they will not be enforceable until this contradiction is removed. Per se, there are pre-constitutional laws which are inconsistent with Indian citizens, but they are not inconsistent with the foreigners. So these kind of laws will not be deleted; they will be kept aside. So these laws will be applied only to the foreigners and will be set aside in the shadow of what? Fundamental rights. And this application is called as what? Doctrine of Eclipse. And in this case, because in our end case, Supreme Court beautifully said that. So these laws will be safeguarded in the shadow of fundamental rights. However, they will not be enforceable in the court of law. So in the next case, in Deep Chand versus State of Uttar Pradesh, 1959, Supreme Court clarified that this doctrine of eclipse, that is safeguarding inconsistent laws which are fundamental rights, inconsistent against fundamental rights, would apply only to the pre-constitutional laws. What Supreme Court said in Deep Chand versus State of Uttar Pradesh in 1959, this doctrine of eclipse would be applied only to the pre-constitutional laws, only to the pre-constitutional laws and not to the post-constitutional laws. And Supreme Court said that post-constitutional laws from the very beginning would become invalid. So that is why in the Ipchen case, Supreme Court said that doctrine of eclipse would be only applied to the pre-constitutional laws. And moving on to the next case, Ambika Mills versus State of Gujarat in 1974. Supreme Court said that we are changing the earlier stance on doctrine of eclipse, and it said that Supreme Court said that doctrine of eclipse would also apply to the post-constitutional laws. Maybe Supreme Court might have thought that the laws that are made by the state legislative assemblies and parliament may be inconsistent now, maybe applicable later. This inconsistency may vanish. So changed its stance and said in Ambika Mills case that doctrine of eclipse would be applied to the post-constitutional laws also. So there is in this case it clarified that the post-constitutional laws would be brought under the shadow of fundamental rights. They violate fundamental rights. So instead of deleting them permanently. However, in recent judgment or in case which happened in 2010, K.K. Punnacha versus State of Karnataka. K.K. Punnacha versus State of Karnataka. Supreme Court reversed its stance and clarified again, and it went back to the judgment in 1959 judgment, which is Deep Chand versus State of Uttar Pradesh, in which it said that it will be applied only to the doctrine of eclipse would be applied only to the pre-constitutional laws. And this stance was again brought back to the limelight by the Supreme Court in this case, K.K. Punnacha versus State of Karnataka, that doctrine of eclipse would be applied only to the pre-constitutional laws and not to the post-constitutional laws. So you have full clarity whether doctrine of eclipse is applicable to the present or post-constitutional laws or not. By saying that only to the pre-constitutional law and not at all to the post-constitutional laws. So, coming to the present, whether doctrine of eclipse would be applicable to the pre-constitutional laws or only to the and also to the post-constitutional laws. The answer is only to the pre-constitutional laws, since the recent judgment will be taken into consideration, and the recent most judgment regarding doctrine of eclipse is what? K.K. Punnicha versus State of Karnataka. In this case, Supreme Court clarified that doctrine of eclipse would be applied only to the pre-constitutional laws if they are inconsistent with the fundamental rights, one or more provisions. Instead of deleting them permanently, they will be kept in the shadow of what? Fundamental rights to ensure future applicability of this laws. In case the inconsistency is removed through act or through laws or through amendment by the parliament. And this is the doctrine of eclipse. I hope you all understood. In this small or brief lecture, we discussed doctrine of severability, doctrine of eclipse, and also briefly the ambit of the article 13 of the Indian Constitution. Article 13 clause 1 says about, as we discussed in the beginning, pre-constitutional laws, if inconsistent, will be null and void. Article 13 clause 2 says about post-constitutional laws, null and void if inconsistent with fundamental rights. And Article 13 clause 3 says about ambit. What does it mean by the law? Like ordinances, laws, acts, permanent law, all these aspects is called as what? Article 13 clause 3. And that's it for today.